as counselor or deputy head of section. He was a member of his country's delegation to the Diplomatic Conference for the Establishment of an International Criminal Court, as well as to the subsequent Preparatory Commission for the ICC. From 2000 onwards, Mr. Kress conducted advisory work in relation to the activities of the International Criminal Court, in particular as head of the drafting board for the regulations of the International Criminal Court. He was appointed as professor in Cologne in 2004 and has been a visiting professor at several universities thereafter. He is a life member of Clare Hall College at the University of Cambridge, a member of the Academy of Sciences and Arts of North Rhine-Westphalia, and the recipient of the 2014 MC Basuni Justice Award. I shall now invite Mrs. Pillai to make the solemn declaration prescribed by the statute, and I request all those present to rise. You have the floor.
I solemnly declare that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank you. I now invite Mr. Kress to make the solemn declaration prescribed in the statute. You have the floor.
Je déclare solennellement.
I declare solemnly that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously. Thank you very much.
I take note of the solemn declarations made by Judge Ad hoc Pillai and Judge Ad hoc Kress and declare them duly installed as judges ad hoc in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar. I shall now recall the principal steps of the procedure in the case. On 11 November 2019, the Gambia filed in the registry of the court an application instituting proceedings against the Republic of the Union of Myanmar, alleging violations of the Convention on the Prevention and Punishment of the Crime of Genocide, to which I will refer as the Genocide Convention. To found the jurisdiction of the court, the Gambia invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Genocide Convention. In its application, the Gambia asserts that the government of Myanmar has adopted, taken, and condoned violent acts against members of the Rohingya group, a distinct ethnic, racial, and religious group residing in Myanmar's Rakhine state. The Gambia contends that these acts were perpetrated in manifest violation of the Genocide Convention and that they are all attributable to Myanmar. The application contained a request for the indication of provisional measures, referring to Article 41 of the statute and to Article 73, 74, and 75 of the Rules of Court. In its request, the Gambia maintains that Myanmar, and I quote, that Myanmar's genocidal acts, end of quote, against the Rohingya group continue to this day, that all members of this group still in Myanmar are at grave risk of further acts of genocide, and that provisional measures are necessary in order to prevent further irreparable harm to the rights protected under the Genocide Convention. The registrar will now read out the passage from the request specifying the provisional measures which the government of the Gambia is asking the court to indicate. You have the floor.
Thank you, Mr. President. I quote, A. Myanmar shall immediately, in pursuance of its undertaking in the Convention on the Prevention and Punishment of the Crime of Genocide of 9 December 1948, take all measures within its power to prevent all acts that amount to or contribute to the crime of genocide, including taking all measures within its power to prevent the following acts from being committed against members of the Rohingya group: extrajudicial killings or physical abuse, rape or other forms of sexual violence, burning of homes or villages, destruction of lands and livestock, deprivation of food and other necessities of life, or any other deliberate infliction of conditions of life calculated to bring about the physical destruction of the Rohingya group in whole or in part. B. Myanmar shall in particular ensure that any military, paramilitary, or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, do not commit any act of genocide, of conspiracy to commit genocide, or direct and public incitement to commit genocide, or of complicity in genocide against the Rohingya group, including extrajudicial killing or physical abuse, rape or other forms of sexual violence, burning of homes or villages, destruction of lands and livestock, deprivation of food and other necessities of life, or any other deliberate infliction of conditions of life calculated to bring about the physical destruction of the Rohingya group in whole or in part. C. Myanmar shall not destroy or render inaccessible any evidence related to the events described in the application, including, without limitation, by destroying or rendering inaccessible the remains of any member of the Rohingya group who is a victim of alleged genocidal acts, or altering the physical locations where such acts are alleged to have occurred in such a manner as to render the evidence of such acts, if any, inaccessible. D. Myanmar and the Gambia shall not take any action and shall assure that no action is taken which may aggravate or extend the existing dispute that is the subject of this application or render it more difficult of resolution. N. E. Myanmar and the Gambia shall each provide a report to the court on all measures taken to give effect to its order for provisional measures, no later than 4 months from its issuance. End of quote. Thank you, Mr. President.
I thank the registrar. Immediately after the application and the request for the indication of provisional measures were filed, the registrar transmitted copies thereof to the government of Myanmar. He also notified the Secretary General of the United Nations. Under Article 74 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same provision states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the hearings in such a way as to afford the parties an opportunity of being represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings during which they could present their observations on the request for the indication of provisional measures had been fixed at Tuesday, 10 December 2019 at 10 a.m. I note the presence before the court of the agents and counsel of the two parties. This morning, the court will hear the Gambia, which has submitted the request for the indication of provisional measures. It will hear Myanmar tomorrow morning at 10 a.m. For the purpose of this first round of oral observation, each party will have available to it a full 3-hour sitting. After the first round of oral observations, the parties will have the possibility to reply. The Gambia will have the floor on Thursday, 12 December 2019 at 10 a.m., and Myanmar will take the floor in turn later that same day at 4:30 p.m. Each of the parties will have a maximum time of 90 minutes in which to present its reply. Before giving the floor to the agent of the Gambia, I wish to draw the parties' attention to Practice Direction 11, which states as follows, and I quote, "In the oral pleadings on requests for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote. In this first sitting, the Gambia may, if required, avail itself of a short extension beyond 1 p.m. in view of the time taken up by the opening part of these oral proceedings. I now give the floor to the agent of the Gambia, His Excellency Mr. Abubakar Mari Tambadou. You have the floor, sir.
Mr. President, honorable judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. The Gambia is also pleased to be represented by a diverse team of dedicated international advocates who will speak after me in the following sequence. Professor Payam Akavan, Mr. Andrew Lowenstein, and Ms. Tafaswa Pasipanochka will each speak about a different aspect of the evidence collected by the United Nations, among others. Mr. Arsalan Suleiman will discuss the court's prima facie jurisdiction. Professor Pierre Darjan will address the plausibility of the rights that are in dispute. Mr. Paul Weichler will address you on the urgency of provisional measures to prevent irreparable harm. And finally, Professor Philip Sands will discuss the specific measures sought by the Gambia and explain why they are needed in these exigent circumstances. I am also pleased that the Gambia's delegation today includes members of the Rohingya community, including those who have traveled from the refugee camps in Bangladesh. Mr. President, honorable judges, as Attorney General of the Republic of the Gambia, I stand before you today as agent in a dispute with the state of Myanmar, but not a conventional one that this court is accustomed to. I stand before you to awaken the conscience of the world and to arouse the voice of the international community. In the words of Edmund Burke, and I quote, "The only thing necessary for the triumph of evil is that good men do nothing, unquote. Honorable judges, every genocide that has occurred in history has had its own causes, unique to its historical and political context. But one thing is certain: genocide does not occur in a vacuum. It does not suddenly spring up or appear overnight out of the blue. It is preceded by a history of suspicion, mistrust, and hateful propaganda that dehumanizes the other and then crystallizes into a frenzy of mass violence in which one group seeks the destruction, in whole or in part, of another. But when we dehumanize others, we dehumanize ourselves as human beings. For any genocide to occur, two things must be present: a dehumanization of the other and the indifference of the international community. It is indeed sad for our generation that 75 years after humankind committed itself to the words "never again," another genocide is unfolding right before our eyes, even as I make this statement to you today. Yet, we do nothing to stop it. This is a stain on our collective conscience, and it will be irresponsible for any of us to simply look the other way and pretend that it is not our business, because it is our business. We sign up to make it our business when we, as civilized nations, committed ourselves to a pact under the 1948 Genocide Convention. Mr. President, honorable judges, in early 2018, I visited the refugee camps in Bangladesh as part of a delegation of the Organization of Islamic Cooperation. As I listened to the stories of the refugees at the camp, I could smell the stench of genocide from across the border in Myanmar. Stories of helplessness in the face of mass killings, of mass rape and mass torture, and of children being burnt alive in the sanctuary of their homes and places of worship. Stories all too familiar to me from a decade and a half of interaction with surviving victims of the 1994 Rwandan genocide in my capacity as a prosecutor at the International Criminal Tribunal for Rwanda. When I looked in the eyes of those refugees as they recounted their devastating stories, I could see the looks of fear, of despair, of desperation, and of destruction. The looks of victims of a modern-day genocide. And so we ask the question, why? Why is the world standing by and allowing such horrors again in our lifetime? Contrary to the views of many out there, it is not only the state of Myanmar which is on trial here. It is our collective humanity that is being put on trial. We are here because it is this court, the International Court of Justice, the principal judicial organ of the United Nations, which epitomizes our collective conscience and whose decisions give hope to millions of people in despair around the world. Indeed, we come to you because we believe in the values that this court has upheld for decades since its creation. because we know that you inspire confidence in the manner that you dispense justice, that you inspire trust in nations around the world, that you treat all sovereign nations, big or small, with equality, and that because you restore hope when all seems lost. As the guardians of our moral and legal compass under the Genocide Convention, we come to you because to the millions of us around the world, the weak, the powerless, the insignificant others, you give us hope that someone out there will listen to us, to our pains and our sorrows, that someone will give consolation to victims and protect them. Today, the Republic of the Gambia is asking you to inspire that same hope which you have given to generations to the Rohingya in Myanmar, to hear their cries of genocide and their cries for help. Every day of inaction means that more people are being killed, more women are being ravaged, and more children are being burnt alive. For what crime? Only because they were born different. Born of a different race and to a different religion from those who killed and raped them. And for this, honorable judges, they have been made to pay the ultimate price, genocide. We must indeed learn lessons from history. It is clear that our best option must remain a strategy to prevent genocide and the conditions that breed it. Peace and justice must rest on the commitment of the international community to protect groups that are under threat and to build societies based on justice and human rights. When strategies of prevention fail, as they unfortunately sometimes do, the intervention of international justice mechanisms which have the capacity to hold states accountable must always follow. Mr. President, honorable judges, reports from various credible international organizations, including the United Nations and the Organization of Islamic Cooperation, indicate that many thousands of people have already died as a direct result of Myanmar's genocidal actions, and the number of refugees on exodus is of biblical proportions. These are not just numbers being floated around or mere statistical data. Each number represents a real human being. I have met and spoken with them. They are the mothers and the fathers, the uncles and aunts, the nephews and nieces. People like you and me. People we all like to have and love in our own families. Every death is being mourned by a family among the Rohingya in Myanmar, and these are the lucky ones. Some families have no one left alive to mourn for them because no member of the family was left alive to tell their story. And we in the Gambia know only too well how it feels like to be unable to tell your story to the world, to be unable to share your pain in the hope that someone somewhere will hear and help, to feel helpless. 22 years of a brutal dictatorship in my own country has taught us that we must use our moral voice in condemnation of the oppression of others wherever it occurs around the world, so that others will not suffer our pain and our fate. Mr. President, honorable judges, this is very much a dispute between the Gambia and Myanmar. We seek to protect not only the rights of the Rohingya, but our own rights as a state party to the Genocide Convention by holding Myanmar to its erga omnes parties obligations not to commit genocide, not to incite genocide, and to prevent and punish genocide. The Gambia has been accusing Myanmar of failure to fulfill these obligations and of carrying out genocide against the Rohingya since at least early 2018, and we have done so regularly in our public and official statements since then. Myanmar has long been well aware of the Gambia's views and has opposed them by denying all responsibility.
You got your statement.
Yeah, I just need to check a few things. There's no interpretation.
There is no interpretation into English.
Yeah. Where's the technician?
I was hearing him just fine.
Can you try and speak so that we know whether the English channel is working now?
Yes, Mr. President.
Go ahead.
Is this working now?
This is the English channel. So far, we have no problem. Possibly it's the French channel that's having a problem.
No, I haven't heard any complaints about the French channel.
There is no interpretation into English at this moment, Mr. President.
Thank you, Mr. Akavan. You may continue.
Thank you, Mr. President. The UN mission came to that conclusion following an exhaustive 2-year investigation by 3 distinguished jurists. The chair was Mr. Marzuki Darusman, Indonesia's former Attorney General. Another member was Ms. Radhika Kumaraswamy, the former chair of the Sri Lanka Human Rights Commission, who was also the UN Special Rapporteur on Violence Against Women and UN Special Representative for Children and Armed Conflict. The other member, Mr. Christopher Sidoti, was Australia's former Human Rights Commissioner. The mission's mandate was established by the UN Human Rights Council in March 2017. It was assisted by experts and advisors from the Office of the UN High Commissioner for Human Rights. Its investigation followed rigorous UN guidelines for best practices. Over 2 years, more than 1,000 victims and witnesses were interviewed, and a vast amount of documents, photographs, and videos were analyzed. Myanmar refused to cooperate with or give access to the mission, but that did not prevent a thorough and impartial investigation. The UN mission's conclusion on Myanmar's continuing genocidal intent and the serious risk of genocidal actions recurring must be given significant weight. This is a finding of fact by an independent inquiry authorized by the United Nations. As the court found in Bosnia versus Serbia in respect of the UN report on Srebrenica, the care taken in preparing the report, its comprehensive sources, and the independence of those responsible for its preparation all lend considerable authority to it. Mr. President, a deeper appreciation of what led the UN mission to this conclusion requires an examination of the wider context of the current situation, to which I now turn. The Rohingya are a distinct ethnic and religious group in Myanmar's Rakhine state, where they have had a historical presence for centuries. This region is depicted in the map at tab 3 of your folders. As set out in the application, the genocidal acts against them have been a long time in the making. They incubated in toxic hate speech on Facebook and Twitter, by which Myanmar demonized an entire group as illegal Bengali immigrants, terrorists and jihadists, maggots and dogs. A Muslim invasion posing an existential threat to Burmese racial purity. The UN mission has pointed to the systematic oppression and persecution of the Rohingya from birth to death, and their extreme vulnerability as a consequence of state policies and practices implemented over decades. Beginning in 2016, there was a dramatic escalation of this persecution in successive waves of what Myanmar described as clearance operations. This was ostensibly against the Arakan Rohingya Salvation Army, but it targeted the Rohingya as such for collective destruction. The UN mission observed that there was not the least effort to make any distinction between ARSA fighters and civilians, or to specifically target a military objective or identify and repel an immediate threat. Everyone was a target and no one was spared. Mothers, infants, pregnant women, the old and infirmed all fell victim to the ruthless campaign. The targeting of women and girls for rape, gang rape, and other forms of sexual violence, as well as the targeting and impact on children in general, has been shocking. It was in this context that the fact-finding mission first concluded in September 2018 that the factors allowing the inference of genocidal intent are present. It did so based on the exacting requirements of Article 2 of the Convention, namely the intention to destroy the protected group in whole or in part as such. It specifically noted that destruction is understood to mean physical or biological destruction rather than the disbandment or expulsion of the group. It found that the actions of those who orchestrated the attacks on the Rohingya read as a veritable checklist of what a state would have done had it wished to destroy the target group in whole or in part. The UN mission was so convinced of its conclusion that it took an extraordinary step. It recommended that named senior generals of the Myanmar military, the so-called Tatmadaw, should be investigated and prosecuted in an international criminal tribunal for genocide. Those named included Myanmar's Commander-in-Chief, Senior General Min Aung Hlaing. The UN Special Rapporteur on Human Rights in Myanmar, Yang Hee Lee of Korea, similarly concluded that the Commander-in-Chief and other senior Tatmadaw generals should be held accountable for genocide in Rakhine. The UN Special Advisor on the Prevention of Genocide, Mr. Adama Dieng of Senegal, also concluded that Rohingya Muslims have been killed, tortured, raped, burnt alive, and humiliated solely because of who they are. The intent of the perpetrators was to cleanse northern Rakhine state of their existence, possibly even to destroy the Rohingya as such, which, if proven, would constitute the crime of genocide. While time does not allow for a complete analysis of the UN mission's massive report, it is instructive to focus on two specific genocidal acts under Article 2 of the Convention. The first is killing members of the Rohingya group under paragraph A. There are detailed accounts of corroborated mass killings in hundreds of villages. Men, women, and children were killed as Tatmadaw soldiers systematically moved from house to house, pulling people out of their homes and executing them, or shooting them inside their houses, or as they left their houses, often in front of family members. The mission also verified a pattern of people, including babies and children, being pushed or thrown into burning houses by Tatmadaw soldiers. The mission found that Rohingya children were specifically targeted. A woman described how at Kien Chanong village, to give but one example, soldiers beat her youngest child. He was 1.5 years old, she testified. He died as a result of the beating. My 4-year-old son's hand was being held by my daughter, who was also stabbed in the head. He started crying, and then the military stabbed him, and he died. Another survivor from Kiet Yo Pin recounted how a pregnant woman in labor, assisted by a midwife and female relatives, were all killed by soldiers, including the newborn baby. Mr. President, the second category of Myanmar's genocidal acts under Article 2 of the Convention is causing serious bodily or mental harm to members of the group under paragraph B. I refer in particular to what the UN mission described as widespread sexual violence, intended to contribute to the destruction of the Rohingya as a group and the breakdown of the Rohingya way of life. In the landmark 1998 Akayesu judgment, the International Criminal Tribunal for Rwanda made clear that when committed with the requisite intent, rape and sexual violence constitute genocide in the same way as any other act. It stressed that this was one of the worst ways of inflicting harm because it resulted in physical and psychological destruction of Tutsi women, their families, and their communities. Destruction of the spirit, of the will to live, and of life itself. The UN mission found that in Myanmar there was a notable pattern of mass gang rape involving multiple perpetrators and multiple victims in the same incident. These crimes were committed in open public spaces, in front of family and neighbors, within forested areas near the village, in large houses within the village, and during detention in military and police compounds. A survivor who had been gang raped with her sister testified how a Tatmadaw soldier told them, "We are going to kill Rohingya. We will rape you. This is not your country." In one case, a large number of interviewees saw dead bodies of women and girls en route to Bangladesh, who they thought had been raped, because the bodies were naked and large amounts of blood were visible between their legs. A survivor who was 8 months pregnant at the time testified that they stamped and kicked my stomach with their boots and then stripped me naked. I was blindfolded and hung by my wrists from a tree. I was raped 9 times. My mother found me in the evening. My unborn baby died. Mr. President, in its 1951 advisory opinion, the court recalled that genocide shocks the conscience of humankind. It is devastating to recount these unspeakable crimes, but the voices of the survivors convey the immense gravity of the request that is now before you. These are the circumstances leading the UN mission to conclude that Myanmar's genocidal intention is ongoing and unabated. In its September 2019 report at tab 2 of your folder, it stated as follows. The mission has identified 7 indicators from which it inferred genocidal intent to destroy the Rohingya people as such, all based on the consideration of indicators of genocidal intent in international case law. First, the Tatmadaw's extreme brutality during its attacks on the Rohingya. Second, the organized nature of the Tatmadaw's destruction. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. Fourth, the insulting, derogatory, racist, and exclusionary utterances of Myanmar officials and others prior, during, and after the clearance operations. Fifth, the existence and discriminatory plans and policies such as the citizenship law and the national verification card process, as well as the government's efforts to clear, raze, confiscate, and build on land in a manner that sought to change the demographic and ethnic composition of Rakhine State, the goal being to reduce the proportion of Rohingya. Sixth, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. And seventh, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law, both as they were occurring and after they occurred. These 7 indicators also allow the mission to infer that the state did not object and in fact endorsed the Tatmadao's clearance operations and the manner in which they were conducted. As indicated at tab 2 of your folder, the UN mission further concluded that every one of these indicators is linked to the acts or omissions of Myanmar state organs, including the military, other security forces, ministries, legislative bodies, the UEHRD, and other civilian institutions. Collectively, they demonstrate a pattern of conduct that infers genocidal intent on the part of the state to destroy the Rohingya in whole or in part as a group. For reasons explained in its 2018 report, there is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. The UEHRD, one of the state organs linked to the genocide, is the Union Enterprise for Humanitarian Assistance in Rakhine State. According to the UN fact-finding mission, it has been responsible for large-scale confiscation of Rohingya land and the bulldozing of burned Rohingya villages, which is likely to have destroyed criminal evidence. Its chairperson is Myanmar's agent in this case. Mr. President, the map on the screen at tab 6 of your folder is satellite imagery analysis by the UN Operational Satellite Application Program, published in October 2018. It shows that in northern Rakhine State, the Tatmadaw had destroyed or partially destroyed 392 villages, comprising 37,700 homes and other structures. But, Mr. President, not all Rohingya villages have been destroyed, at least not yet. Some 600,000 Rohingya remain in Myanmar. They are in urgent need of protection. As the fact-finding mission concluded just a few weeks ago, they remain under serious risk of genocide. Mr. President, distinguished members of the Court, this concludes my presentation. Mr. Lowenstein will now describe further evidence of Myanmar's genocidal intention. I thank you for your kind attention and ask that you call him to the podium.
I thank Professor Akavan for his statement. I now invite Mr. Lowenstein to take the floor. You have the floor.
Mr. President, members of the Court, it is a special honor to appear before you in this most serious of cases. I will address further evidence of Myanmar's genocidal actions and ongoing genocidal intent. As the UN fact-finding mission emphasized in its most recent report, every risk factor used by the UN Office on Genocide Prevention to forecast genocide is present in Myanmar today. Myanmar's genocidal intent is rooted in its long-standing policy that the Rohingya, by dint of their ethnic and religious differences, constitute an existential threat to Myanmar's racial and religious purity and to the country's well-being. As the UN mission documented, Myanmar is saturated with anti-Rohingya writings that evoke the supposed threat to Myanmar's demographic balance, bearing titles like Fear of Extinction of the Race. They warn that unless preemptive action is taken, the whole country will be swallowed by the Muslim Kalars, a racial slur used to describe those with dark skin and foreign ancestry. Mr. President, dehumanizing language is prevalent. The Rohingya are described as a black tsunami. They are likened to poisonous plants. They are compared to African catfish, an invasive species that must not be allowed into the country to breed. Myanmar's law codifies this ideology. Anyone who does not belong to a national race, and that is the term used in these laws, is denied even basic rights. To this day, Myanmar's Ministry of Labor, Immigration and Population maintains this as its guiding motto: the earth will not swallow a race to extinction, but another race will. The UN Special Rapporteur in May of this year reported that hate speech is prevalent and underscored that senior government officials traffic in it. Both Facebook and Twitter have been compelled to suspend the account of the Commander-in-Chief of Myanmar's armed forces. Why? For engaging in hate speech. An academic study published earlier this year examined Myanmar's state media. It concluded that the state-owned press mirrors the extreme speech of nationalists and signals the state's approval. Mr. President, it is not only the Myanmar state that engages in hate speech. The government's actions have fostered an environment that is rife with extreme racist rhetoric. In August, the UN Special Rapporteur warned again that hate speech remains prolific. As the fact-finding mission concluded, the fact that Myanmar harbors genocidal intent is evidenced by its toleration for public rhetoric of hatred and contempt for the Rohingya. Investigative reporting by Reuters last year identified more than 1,000 examples of extreme hate speech posted on Facebook alone. Many refer to the Rohingya as Kalars. Others call them dogs, maggots, and rapists, suggest they be fed to pigs, and urge they be shot or exterminated. Here are some examples. Kill all the Kalars that you see in Myanmar. None of them should be left alive. If it's a Kalar, get rid of the whole race. Kalar dogs, the Bengalis, are killing and destroying our land, our water, and our ethnic people. We need to destroy their race. We must fight them the way Hitler did the Jews. Pour fuel and set fire so they can meet Allah faster. Mr. President, the fact-finding mission also concluded that Myanmar's genocidal intent is evident in its lack of remorse or even acknowledgement of any wrongdoing. Instead, the Tatmada's actions are glorified. The review of state media showed that Myanmar presents the situation as the Tatmada gallantly defending the nation's sovereignty against Muslim terrorists. Myanmar denies responsibility for its crimes against the Rohingya, even when confronted with evidence of genocidal acts at specific locations. I will give 3 examples. One from each of the townships in Rakhine State with significant populations of Rohingya. In each instance, Myanmar has refused to acknowledge any wrongdoing. I will begin at Mingyi in Mongdo Township. You can see its location on the map on your screens. This is a village where every witness interviewed by the fact-finding mission identified Tatmadaw soldiers as the main perpetrators, and where a survivor reported the Tatmadaw saying, "We have the order to kill everyone," which is precisely what they tried to do. The fact-finding mission estimates that at least 750 people were killed at Mingyi alone. Many were shot, including those who tried to escape by swimming across a river. One survivor described how the military killed those who were hiding. Whoever moved was shot. If they looked up or moved their heads, they were shot. The Tatmadaw rounded up hundreds of Rohingya who could not escape. They separated women and children from the men and systematically killed the men. A witness recounted, "The first round of shooting was like a rain of bullets. The second round was slow, as the soldiers killed the men individually. They aimed a gun at each man and shot. The soldiers killed those who had survived gunshot wounds with long knives." The Tatmadaw next turned to the women and children. Some children were shot. Other children were thrown onto a fire. A witness described how the soldiers took infants from their mothers, threw them into the river. Another recounted the slashing of breastfeeding-aged children. Another described seeing soldiers stabbing a 10-year-old boy while he was trying to run away. One survivor told the mission that 7 of her children were killed. Rape was also widespread. At Mingyi, the Tatmadaw took women and girls in groups of between 5 and 7 into houses where they were beaten, brutally raped, and frequently stabbed. The young children and infants with them were killed or severely injured, often by stabbing. The houses were then locked and then set on fire. One survivor who escaped from such a burning house recounted, "I entered the house with 4 of my neighbors, and 3 of us had babies. I knew the house. There were dead bodies on the floor, young boys and older men from our village. As we entered the house, the soldiers locked the door. One soldier raped me. They stabbed me in the back of my neck and in my abdomen. She continues, I was trying to save my baby, who was only 28 days old, but they threw him on the ground and he died. The other women who were there were also raped. Satellite imagery analyzed by UNISAT reveals that Myingyi and its associated hamlets, numbering some 440 structures, were completely burned and destroyed. By contrast, a village to the south, inhabited by ethnic Rakhine, a predominantly Buddhist ethnic group, remains intact. What does Myanmar say about Myingyi? The answer was given by the spokesperson for Myanmar's agent in this case. He blamed the Rohingya. He said it was the ethnic Rakhine and security forces who had been attacked by what he referred to as hundreds of terrorists. Myanmar likewise denies wrongdoing at any of its other thoroughly documented clearance operations, including the one at Maung Nu in Busidong Township, the location of which you can see on your screens. The operation was carried out by a large group of Tatmadaw soldiers who entered the village in military trucks. A witness recounted that many people were taken to the edge of the hillside and shot. The soldiers approached a compound where a large number of Rohingya had sought shelter and ordered the people to come out of the houses or else the buildings would be set on fire. The soldiers separated women and children from men. At gunpoint, the soldiers ordered the women to remove their headscarves, which they used to blindfold the men and boys and tie their hands behind their backs. The soldiers then opened fire on the men and boys and slit their throats with knives. A witness describes how some of them were shot first, and then their throats were slit with a knife. Others just had their throats slit. The Tatmadaw killed children in the courtyard. One witness recounted, the soldiers killed the male members of my family. They shot them first and then slit their throats. The courtyard was full of blood. They killed my husband, my father-in-law, and my two nephews of 15 and 8 years old. They even killed the child in the same way. The fact-finding mission estimates that up to 100 people, mostly men and boys, were executed. 28 of the victims were under 18 years old. Women and girls were gang raped, killed, and mutilated. A victim described how 3 members of the military took me. One man held me down and pushed me to the ground. They tore off my clothes. 2 men raped me. One witness saw a woman killed by being knifed in the vagina. UNISAT satellite imagery shows that Maung Nu and a neighboring Rohingya village were systematically burned over a period of several days. More than 320 structures were destroyed. The spokesperson for Myanmar's agent in these proceedings dismissed the evidence against the Tatmadaw officer in command of the battalion that carried out this clearance operation as nothing more than what he called unreliable accusations. Myanmar has also refused to acknowledge responsibility for the clearance operation at Pyat Chin in Rasidong Township, which is now shown on your screens. The fact-finding mission determined that hundreds of Tatmadaw soldiers participated. After surrounding the village, they opened fire, shooting at villagers, including those who were fleeing. The perpetrators dragged people from houses and shot them at point-blank range. Others were killed by having their throats slit with large knives. One survivor recounted, "If people were not killed by the gunshots, they were slaughtered to make sure they were really dead." An elderly woman described being pulled from her house with her 70-year-old brother. "Soldiers used rifle butts to beat my brother on the head, and I saw his brains come out. I saw people being killed with long knives. The soldiers were also spraying bullets, and many people were injured and killed. Our village was full of dead bodies. I saw dozens of people killed. First, they shot the people, and then, if they were still alive and the body was moving, they used a machete to slaughter across the throat." The Tatmadaw set houses on fire, including those still occupied. Other victims were forced inside houses before they were intentionally set alight. In one house, between 6 and 7 men were forced inside. Those unable to escape were burned alive. The fact-finding mission concluded that the Tatmadaw specifically targeted children, including infants and babies. Some were wrenched from their mother's arms and thrown to the ground. Others were thrown into fires and burned alive. Women and girls were subjected to rape, gang rape, sexual mutilation, and sexual humiliation. The Tatmadaw took some to a makeshift military base where mass gang rape occurred. These victims were subjected to serious physical injuries either before being raped or after being killed, including the mutilation of their breasts. UNOSAT's analysis of satellite imagery confirms that the entire village was destroyed. By contrast, the nearby non-Rohingya village remains intact. The fact-finding mission estimates that the Tatmadaw killed 358 people at Shutpin. The victims included 127 children, all under the age of 6. What does Myanmar say about Shutpin? Just a routine security operation. The Tatmadaw were searching for militants. No more than 10 people died. There were no rapes. The Rohingya burned their own homes. Mr. President, the fact-finding mission concluded, based on these and other atrocities, that Myanmar's genocidal intent is evidenced by, inter alia, the Tatmadaw's extreme brutality during its attacks on the Rohingya, the organized nature of the Tatmadaw's destruction, and the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. The fact-finding mission concluded that further evidence of Myanmar's genocidal intent consists of its lack of accountability or even public condemnation of crimes like those we just reviewed. This conclusion, Mr. President, is consistent with the UN Special Rapporteur's report last month that Myanmar's government allows the military to operate with impunity, even though it is responsible for, in the Special Rapporteur's words, the extreme violence that was inflicted during clearance operations which were executed on an unprecedented scale and with an unprecedented brutality, all indicators of genocidal intent. Mr. President, members of the court, this concludes my presentation. I thank you for your kind attention and ask that you invite to the podium Ms. Pashpanoscha.
I thank Mr. Lowenstein, and I invite Mrs. Pashpanoscha to take the floor. You have the floor, Madam.
Mr. President, members of the court, good morning. It is an honor for me to appear before you on behalf of the Republic of the Gambia. You have already heard from my colleagues about the genocidal acts that have been committed against the Rohingya by Myanmar, up to and through the presentation of the United Nations fact-finding mission report of 16 September 2019. It is my role to address the situation of the approximately 600,000 Rohingya who remain in Myanmar today. Their situation is one of extreme vulnerability, with ongoing acts of genocide against them, and the grave risk that even more heinous atrocities, a new clearance operation, or worse, will be inflicted upon them at any time. As the independent fact-finders have made clear, the evidence of Myanmar's genocidal intentions has actually strengthened over the past year. In the words of the distinguished Nobel laureate Toni Morrison, who passed away just a few months ago, let us be reminded that before there is a final solution, there must be a first solution, a second one, and even a third. The move toward a final solution is not a jump. It takes one step, then another, then another. I will therefore draw your attention to the steps Myanmar is taking currently that reflect its continuing intention to destroy the Rohingya as a group. Each of these steps has been reported by the highly credible, independent, and eminent investigators acting under the authority of the United Nations, intergovernmental organizations, and human rights organizations. Each of these steps heightens the Rohingya's vulnerability, points towards further acts of genocide, and foretells the risk of more violations of the Genocide Convention. The first step is the forceful segregation and confinement of 20% of the Rohingya in internment camps and ghettos, where they are in situations of extreme precariousness. As the UN fact-finding mission reported, Myanmar forcibly transferred over 120,000 Rohingya men, women, and children into displacement camps outside Sitwe town in central Rakhine State in June 2012. For over 7 years now, Myanmar has cordoned them off from the outside world with barbed wire, police checkpoints, and military posts, restricted their movements, subjected them to physical and mental abuse, and maintained them in a state of fear for their survival. They remain in that state, easy targets for the next wave of mass killings, especially as they are guarded by the same Tatmadaw that carried out the clearance operations. Myanmar claims its confinement of the Rohingya in their displacement camps is for their own good. It claims this is necessary to ensure the protection of the communities from intercommunal violence between the ethnic Rakhine and the Rohingya. But as the UN fact-finding mission report points out, Myanmar has not shown how any actual risks justify this extreme and indefinite restriction of movement. At times, Myanmar has simply denied that there are any restrictions on the interned Rohingya population. Yet, as the UN fact-finding mission observed, the existence of the restrictions on the movement of the displaced population is undeniable. It is attested by the checkpoints and signboards at the entry of the camps, the barbed wires, the experience of those trying to leave the camps, and the simple fact that over 120,000 people have not been able to go back to their place of origin despite their desire to do so. Myanmar has confined a separate group of Rohingya in the Aung Mingala quarter of Sitwe town. The UN fact-finding mission explained that this quarter is effectively a closed ghetto where Muslims are trapped and have lived separately from the rest of the population since 2012. It is guarded by armed police, checkpoints, and barbed wire. The Tatmadaw maintains a small presence in the school grounds. People can only leave the quarter with special permission and in organized convoys with police escorts. The remaining 80% of the Rohingya reside in villages under close watch by the Tatmadaw. The UN fact-finding mission's September 2018 report explained that these Rohingya are required to obtain travel permits to leave their villages, and they're generally not permitted to travel to ethnic Rakhine areas, including the main towns and markets. The September 2019 report indicated that the restrictions have increased in severity over the past year. It noted that the government currently restricts the freedom of movement of Rohingya through a combination of local orders, verbal instructions, security checkpoints, soldiers, and patrols, which have the cumulative effect of confining them to their villages and camps. The UN fact-finding mission has concluded that this state-mandated segregation fosters a conducive environment for dehumanization and hate campaigns. Yet, Myanmar is building more internment camps for those Rohingya who have not yet been interned. Refugees arriving in Bangladesh informed the Office of the High Commissioner for Human Rights that the Tatmadaw is forcing men and children as young as 12 years of age to perform unpaid work on 12-hour shifts to build houses in camp-like facilities in different locations in northern Rakhine State. According to the UN High Commissioner for Human Rights, one interviewee stated, the inhabitants of his village, which was largely untouched by the violence of 2017, were informed by the village administrator that they would be removed from their homes to a newly constructed camp. Other interviewees described the camps as closed areas with only one entry gate, surrounded by barbed wire and watchtowers. Yet another interviewee expressed fears that the camps had been built with the objective of forcing the Rohingya to live in miserable conditions with the eventual intention of exterminating them. Mr. President, the extermination of the Rohingya, who have been rounded up into internment camps and closely guarded ghettos and villages, can come swiftly, at any time, in the form of new clearance operations perpetrated by security forces who are stationed there. Or it can occur in slow motion, through denying them food and other essentials of life. The UN fact-finding mission, in its most recent report, found that while the former method of destruction could be resumed at any time, the latter method is already in progress. The government has severely restricted access to food for Rohingya in Rakhine State, and the resulting food insecurity is being caused by government laws and policies. Article 2C of the Genocide Convention identifies deliberately inflicting conditions of life calculated to bring about a group's physical destruction in whole or in part as a genocidal act. Myanmar is implementing its policy of denying food to the Rohingya by various means, including its widespread confiscation of agricultural lands on which the Rohingya grew crops, essential to their survival. The UN fact-finding mission determined that Myanmar is undertaking a concerted effort to confiscate these lands. The ongoing confiscations extend beyond the Rohingya villages that Myanmar destroyed during the clearance operations. Rohingya-owned and cultivated land has now been confiscated in areas of northern Rakhine State, where Rohingya remained. Members of the Rohingya group are no longer allowed to consume products from their own lands following the confiscation. The UN fact-finding mission explained that the Tatmadaw is also depriving the Rohingya of food by deliberately killing or confiscating their livestock without permission or payment. One interviewee who fled Butchidang Township explained how this was conducted in his case. Military, police, members of ethnic Rakhine constantly came to the village and looted everything, including food items. The military took away my 7 cows that I was grassing in the hillside. I cultivated rice in my land. When it was ready for harvesting, members of ethnic Rakhine snatched the harvest. I was left with nothing except 2 goats, which I had to offer to the military for my release. As the UN Special Rapporteur reported, based on the evidence it found, there appears to be a policy of forced starvation in place, designed to make life in northern Rakhine unsustainable for the Rohingya who remain there. The Committee on the Elimination of Discrimination Against Women made the very same determination earlier this year. Mr. President, a further step Myanmar is taking against the Rohingya as a group is the intensified effort to force them to accept national verification cards that explicitly recognize cardholders as non-citizens and brand them as Bengalis. While the Rohingya are loath to accept the national verification cards, which erode their right to the identity, without them, they are denied access to essential life-saving and life-supporting foods and goods and services. The UN fact-finding mission has found that all of these steps, the manner in which the government deprives Rohingya of land, the manner in which the government imposes movement restrictions and deprivation of food, and the manner in which the government denies the Rohingya their identity and deprives them of the rights people need to survive and live with dignity, are ongoing and support a conclusion that the government continues to harbor genocidal intent and that the Rohingya remain under serious risk of genocide. As the UN fact-finding mission concluded just 2 months ago, the Rohingya remain the target of a government attack aimed at erasing their identity and removing them from Myanmar. And this has caused them great suffering. The laws, policies, and practices that formed the basis of the government's persecution against the Rohingya have been maintained. Their plight can only be considered as having deteriorated. Similarly, the UN Special Rapporteur on the situation of human rights in Myanmar stated just 2 weeks ago, the system of oppression the Rohingya are subjected to remains unchanged, and they are at real risk of recurring genocide. Mr. President, if the Rohingya are to be protected against further acts of genocide, it will be up to the court to order the provisional measures that are necessary for their protection. There is no other alternative. Certainly, Myanmar cannot be counted on to protect them from itself. In the past few years, it has appointed numerous commissions to investigate the genocidal acts that have been reported by the UN fact-finding mission and other international observers. None of Myanmar's commissions have found any violations of internationally protected rights. As the UN Commissioner for Human Rights concluded earlier this year, the establishment of commissions of inquiry has become routine after cyclical episodes of violence in Myanmar, with 8 such commissions having been established since 2012. None of the previous commissions has led to the prosecution of any Tatmadaw official. All have been exonerated. Likewise, the UN fact-finding mission concluded in September of this year, Myanmar is not meeting its obligations under the Genocide Convention to conduct an independent criminal investigation into allegations of genocide. The mission draws this conclusion based on the government's pattern of ignoring compelling evidence that genocide took place on its territory and its failure to put in place investigative mechanisms that are independent, prompt, thorough, effective, credible, and transparent. Typical of Myanmar's own investigative mechanisms is its advisory board for the Committee for Recommendations on Rakhine State. It is one of a very few that included international members. Among them was Ambassador Bill Richardson, a former US representative to the United Nations. He resigned after the first round of meetings, denouncing the board's so-called investigation as a whitewash. Kobsak Chutikul, a Thai diplomat who served as the board's secretary, quit soon thereafter, expressing his concern that the board's existence was going to divert attention from the issues, give a false impression that things are being done. Instead, he said, Myanmar government officials did no more than defend the line that this is an internal matter. We are handling it. We haven't done anything wrong. This is a false narrative. Mr. President, it is Myanmar's narrative that is false. It is also reprehensible. This is what the chairperson of a state-level investigative committee said about the widespread and well-documented rape of Rohingya women. He said it was inconceivable because they are very dirty. The Bengali Rohingya women have a very low standard of living and poor hygiene. They are not attractive, so neither the local Buddhist men nor the soldiers are interested in them. The chairperson of Myanmar's investigative committee was not the only one to categorically deny that Tatmadaw soldiers have raped Rohingya women. What you see now before you, and at tab 18 of your judges' folders, is a current screenshot from the Facebook page of Myanmar's agent in these proceedings. As you can see, the Facebook page insisting fake rape belongs to the Myanmar State Consular Office. Mr. President, members of the court, in the Gambia's view, Myanmar's false narratives, like these, and its sham investigations further demonstrate the need for you to order provisional measures to compel it to live up to its obligations under the Genocide Convention during the pendency of these proceedings to protect the Rohingya from recurring acts of genocide. Next, my colleagues will show how each of the requirements for provisional measures set out in Article 41 of the Court Statute is fully satisfied, and they will describe the specific provisional measures that are called for in these exigent circumstances. I thank you for your kind attention and ask that you call next to the podium, after the break if you are so disposed, Mr. Arsalan Suleiman, who will address the court on its prima facie jurisdiction over the Gambia's claims.
I thank Mrs. Pasipanodja. Before I give the floor to the next speaker, the court will observe a coffee break of 10 minutes. The sitting is adjourned. Please be seated. The sitting is resumed. I will now give the floor to Mr. Arsalan Soleiman. You have the floor.
Mr. President, members of the court, it is an honor to appear before you and to represent the Gambia in these proceedings. Before the break, you heard the terrible details of the genocidal acts perpetrated by Myanmar's military and security forces against the Rohingya group in Myanmar's Rakhine State. Now, and in the remainder of the Gambia's presentation today, you will hear how these circumstances not only require, but compel the indication of provisional measures under Article 41(1) of the court's statute. The standards that guide the court in ruling on the Gambia's requested provisional measures are well established. First, the court must be satisfied that it has prima facie jurisdiction over the dispute. I will address the elements of that requirement. Second, the rights asserted by the Gambia must be at least plausible, and there must be a link between those rights and the measures requested. Professor Pierre Dargent will speak to this. Third, there must be a showing of urgency and a risk of irreparable harm, which my colleague Paul Reichler will amply demonstrate. Finally, Professor Philippe Sands will identify the specific provisional measures that are requested and explain why they are required. Now, with the court's permission, I will turn to prima facie jurisdiction. The Gambia has invoked the court's jurisdiction pursuant to Article 36(1) of the Statute of the Court and Article 9 of the Genocide Convention, which provides disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice at the request of any of the parties to the dispute. Both the Gambia and Myanmar are parties to the convention. Myanmar deposited its instrument of ratification on 14 March 1956, and the Gambia deposited its instrument of accession on 29 December 1978. Pursuant to its terms, the convention became applicable between the parties 90 days thereafter. Neither Myanmar nor the Gambia entered any reservation to Article 9 of the convention. Both parties to this dispute have, therefore, consented to the court's jurisdiction over disputes between the contracting parties on the interpretation, application, or fulfillment of the Genocide Convention. Because the Gambia has invoked jurisdiction pursuant to Article 9 of the Convention, the court must determine whether the acts complained of are prima facie capable of falling within the provisions of that instrument, and whether, as a consequence, the dispute is one which the court has jurisdiction ratione materiae to entertain. As set forth in its application, the Gambia has alleged that Myanmar is responsible for committing genocide, for attempting to commit genocide, for conspiring to commit genocide, for inciting genocide, for complicity in genocide, and for failing to prevent and punish genocide. Clearly, the acts complained of fall directly within the provisions of the Convention. The allegations are specific and reflect, and in many cases repeat, the conclusions reached by the United Nations fact-finding mission and other authoritative UN bodies, that acts of genocide have occurred and are likely to continue to occur. There can be little doubt that the court has jurisdiction ratione materiae. Further, there is an unambiguous dispute between the parties. As the court has frequently held, a dispute between states exists where they hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations, and where the claim of one party is positively opposed by the other. The existence of a dispute is a matter for objective determination. If the parties have made explicit reference to the specific treaty in dispute, as the Gambia has in fact done in this case, such an express specification would remove any doubt about one state's understanding of the subject matter in issue and put the other on notice. Mr. President, Myanmar was put on notice of this dispute under the Genocide Convention on several occasions, and it acknowledged receipt of that notice prior to the Gambia's filing of this case. From 5 to 6 May 2018, the member states of the Organization of Islamic Cooperation, OIC, including the Gambia, met at a ministerial level in Dhaka, Bangladesh, where, among other actions, they promulgated the Dhaka Declaration. That declaration expressed concern over the systematic, brutal acts perpetrated by security forces against the Rohingya, which constitute a serious and blatant violation of international law, and sought to address the accountability issue for the violations against the Rohingyas in Myanmar through the formation of an ad hoc ministerial committee to be chaired by the Gambia. In response, Myanmar's Ministry of Foreign Affairs issued a press statement 3 days later to categorically reject the declaration's description of events in Rakhine State as state-backed violence. Myanmar was thus on notice as early as May of 2018 of the newly formed OIC Ad Hoc Committee on Accountability for Crimes Against the Rohingya, chaired by the Gambia, and its allegations of state-sponsored violence against the Rohingya. In September of 2018, the United Nations fact-finding mission on Myanmar released its first series of reports in which it found evidence of genocidal acts and genocidal intent attributable to Myanmar in the context of its crimes against the Rohingya. Myanmar dismissed those findings as biased. The Gambia, on the contrary, made clear in its remarks at the United Nations General Assembly later that month that the Gambia has undertaken to champion an accountability mechanism that would ensure that perpetrators of the terrible crimes against the Rohingya Muslims are brought to book. On 2 March 2019, the member states of the OIC held another ministerial level meeting at which they, including the Gambia, adopted a resolution on Myanmar's crimes against the Rohingya, which emphasized that accountability was necessary for preventing genocide, and endorsed the recommendation of the ad hoc committee chair to hold Myanmar accountable under the Genocide Convention. In response, Myanmar again denied responsibility and criticized the resolution as an interference with its sovereignty. On 16 September 2019, the United Nations fact-finding mission submitted its second report. Myanmar rejected wholesale the fact-finding mission's report, which welcomed the efforts of states, in particular the Gambia, to encourage and pursue a case against Myanmar before the International Court of Justice under the Genocide Convention. The Gambia, in remarks before the United Nations General Assembly on 26 September 2019, at which Myanmar was present, confirmed that the Gambia is ready to lead the concerted efforts to take the Rohingya issue to the International Court of Justice on behalf of the Organization of Islamic Cooperation, and we will call on all stakeholders to support that process. As a global community with a conscience, we cannot continue to ignore the plight of the Rohingya. On 11 October 2019, in furtherance of its support of the conclusions of the UN fact-finding mission, the Gambia's permanent mission to the United Nations sent a note verbal to Myanmar's permanent mission, expressing the Gambia's concerns regarding the ongoing genocide against the Rohingya people in violation of Myanmar's obligations under the Genocide Convention. Noting Myanmar's rejection of the fact-finding mission's report, the Gambia emphatically rejected Myanmar's denial of its responsibility for the ongoing genocide against Myanmar's Rohingya population and its refusal to fulfill its obligations under the Genocide Convention and customary international law. The Gambia concluded its note verbal by declaring, with somber reflection on the goals of the Genocide Convention and its obligations on all states, the Gambia understands Myanmar to be in ongoing breach of those obligations under the Convention and under customary international law. The Gambia insists that Myanmar take all necessary actions to comply with these obligations, including but not limited to its obligations to make reparations to the victims and to provide guarantees and assurances of non-repetition. Myanmar received the Gambia's note verbal on the date it was sent. Myanmar confirmed this by means of its own note verbal to the Gambia's mission to the United Nations, sent from the same email address to which the Gambia had sent its note verbal. Although the court has previously held that a formal diplomatic protest is not required, here there was one, in addition to direct statements and actions in multilateral settings and additional indicia of Myanmar's awareness of this dispute under the Genocide Convention. Mr. President, members of the court, the Gambia's case against Myanmar prima facie falls squarely within the provisions of Article 9 of the Genocide Convention. A dispute over Myanmar's failure to fulfill its obligations under the convention plainly exists. And Myanmar was well aware of this dispute prior to the filing of the application. Mr. President, members of the court, there can be no doubt that the court has prima facie jurisdiction over the Gambia's claims I thank you and the court for your kind attention and ask that you call Professor Pierre d'Argent to the podium.
I thank Mr. Soleiman for his statement. J'invite maintenant.
I would now like to invite Professor Pierre d'Argent to take the floor. You have the floor, sir. Thank you very much, Mr. President. Mr. President, Madam Vice President, honorable judges, it is an honor for me to take the floor before you today and to speak today in support of the noble cause presented by Gambia in the dispute against Myanmar. It behooves me to address the second condition, which is necessary for the exercise of the court's jurisdiction and for the indication of provisional measures. This second condition relates to the rights claimed, which, according to Gambia, require urgent protection. The jurisprudence of the court on this issue is well established, and as you already pointed out on 14 June last, it is relevant to determine whether the rights claimed for which protection is sought are plausible rights, taking account of the basis of the court's prima facie jurisdiction in the proceedings. Thus, these alleged rights must have a sufficient link with the subject of the proceedings before the court on the merits of the case. End of quote. This is surely the case in these proceedings. After pointing at several essential elements pertaining to the normative character of the Genocide Convention as they arise from your own jurisprudence, I will more clearly address the subject of this judicial proceedings and which Gambia is requesting the protection of, and that is the nature of these rights will clearly arise before you. I will point out that in Article 41 of the statute, nothing denies the court's jurisdiction in ordering provisional measures when the rights claimed are of the nature of those under the convention. Mr. President, in the consultative opinion of 1951, the court addressed what it called the special characteristics of the Genocide Convention, and it pointed out, and I quote, the intention of the United Nations to condemn and punish genocide as a crime under international law involving a denial of the right of existence of entire human groups. End of quote. This right, the right of existence of the Rohingya human group, is a right which Myanmar is bound to show respect for, and thus also to respect those rights for all state parties to the Convention on Genocide. By addressing the court, Gambia is attempting to protect the right of the Rohingya group to exist, nothing more and nothing less. The nature of the rights enshrined by the Convention is closely tied to this object, and thus by examining these, the court pointed out that in such a convention, the contracting states do not have interests of their own. They merely have, one and all, a common interest, namely the accomplishment of those high purposes which are the raison d'être of the convention. Consequently, in a convention of this type, one cannot speak of individual advantages or disadvantages to states or the maintenance of a perfect contractual balance between the rights and duties. End of quote. Since that date, the court has pointed out that the specific provisions of the Convention clearly say that the rights and obligations enshrined by the Convention are rights and obligations erga omnes. Furthermore, the court has pointed out that the norm prohibiting genocide was surely a peremptory norm of international law, jus cogens. There is therefore no doubt, Mr. President, ladies and gentlemen of the court, that the Gambia indeed is rightfully invoking the responsibility of the respondent for breaches in the convention. In fact, the Convention Against Torture is something that you pointed out, saying that the obligations were erga omnes partes, and therefore state parties to the convention could invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with such obligations. And as the court pointed out, it is in the common interest of the state parties that there is compliance with the relevant obligations under the convention, and that is what justifies that all states should be able to invoke the responsibility of any other state for a breach, in the knowledge that, and again I quote the court, if a special interest were required for that purpose, in many cases, no state would be in the position to make such a claim.
In 2012, the court ruled on the subject of erga omnes partes obligations when it came to the Convention Against Torture, and that would be even more so. The same should apply, as we all know, since the Barcelona traction case on the subject of the Genocide Convention as well. The court has characterized as erga omnes obligations these obligations as well, and every state can invoke the responsibility of another state for breach of the special obligations of the Genocide Convention without having to justify a particular interest. In reality, the state that invokes the responsibility of another state for violation of the erga omnes obligation doesn't need to have a reason to do so. However, the interest is not of a specific nature, and this interest, that is shared by all states, is something that is shared. And Mr. President, through the action that is instituted against Myanmar, the Gambia is implementing the right it holds to make sure that the convention is duly executed. The convention enshrines obligations, but also erga omnes rights, and these rights are the exact reflection of these obligations. Collective obligations of the conventions are associated for rights for each contracting party to ask and obtain its execution, whereas the erga omnes character of the obligations represents the basis, the right of each state party of the convention consists in demanding the respect of primary legislation, that is to say, the duty of the responsible state to perform the obligation breached. It is therefore certain that Gambia holds rights that are its rights, and it wishes for the rights to be respected through this jurisdictional procedure. And therefore it is entirely compatible with Article 41 of the statutes, because Gambia's right to have that Myanmar fully executes the convention is seriously imperiled due to the behavior of the defending state. Furthermore, by looking at protecting its right as a state party of the convention, the Gambia is also trying to ensure the protection and to use what the court said, the right of existence of an entire human group, that is to say, the Rohingya group. And in this respect, it is not necessary to determine whether the convention personifies groups or if individuals of that group are vested with these rights directly as members of protected groups' rights on which they could rely before the court. One can note that the main purpose of the objective is the safeguard of all national, ethnic, racial or religious groups as such. And since the convention bars genocide as being total or partial physical destruction of such a group, it is essentially protecting the members to life and to physical and mental integrity. It is in this sense, therefore, that the Genocide Convention is very often considered as the very first modern treaty and that protects human rights. each criminal act as defined under Article 2 is being infringed because it is a group that is protected through its members rather than through its heritage or its territory or cultural language. It is about human beings, men, women, and children who, due to the fact that they belong to that group, are protected by the convention, just like the group is protected by the convention. Therefore, the Gambia would like to enforce the respect of its own right that all members of the Rohingya group subjected to the act of genocide are protected. Therefore, the court should declare that such a right is plausible, that is to say, it is grounded in a possible interpretation of the convention. And this is decidedly the case because by imposing on the contracting parties the obligation to prevent and to punish genocide, the convention protects the groups that it targets as well as their members. In this respect, the beneficiaries of the rights provided by the convention are not just the state parties but also groups and their members, and it is their fundamental rights that are violated every time the convention is violated. It is their rights that are protected by the convention every single time when acts covered by the terms of the convention constitute the acts that are likely to infringe the essential human rights. And thus, and I would like to quote the report of Judge Gaia at the International Institute for Law, who said, a group threatened with genocide has a right towards all the states that genocide should not be committed and be prevented and punished. Mr. President, honourable members of the court, the Article 41 of the statute enables you to protect the rights that the Gambia holds under the convention and also includes those of the Rohingya to not be exposed to genocidal acts. Therefore, the rights claimed and protected under provisional measures are the rights that the requesting party is asking for protection. That is to say, rights which are the subject of dispute in judicial proceedings. Therefore, protecting the rights forming the subject of the dispute submitted to the court while awaiting judgment as to the merits of the court. In the provisional measures in the Bosnia-Herzegovina court, the court recalled that these rights were protected on the merits, which might ultimately form the basis of a judgment. And Article 41 enables, therefore, that Gambia can solicit protection for all the rights which are the subject of the dispute. Any other conception would be tantamount to restricting in an absurd manner the incident jurisdiction of the court on provisional measures, an area in which it is dearly needed. The measures requested by the Gambia have the manifest intention to protect these rights and represent a link with the rights of which protection is requested, as Professor Sands will mention at the end of the hearing. Honourable President, ladies and gentlemen, I would like to thank you for your kind attention, and I would like to ask you to request Mr. Paul Reichler onto the rostrum, who is going to talk to us about the urgency and irreparable harm to rights claimed. Thank you very much for your attention.
Thank you very much, Pierre d'Argent. I'd now like to give the floor to Mr. Paul Reichler.
Mr. President, members of the court, good afternoon. It is, as always, an honor for me to appear before you. This time, it is both a special privilege and a grave responsibility to represent the Gambia in its effort to prevent further acts of genocide against the Rohingya people in Myanmar. These horrific acts committed by the state of Myanmar have been comprehensively documented by the United Nations Fact-Finding Mission, the UN High Commissioner for Human Rights, the UN Special Rapporteur on the Situation of Human Rights in Myanmar, the UN Special Advisor on the Prevention of Genocide, and numerous independent human rights organizations and experts. Based on these highly credible reports, it is blindingly obvious that there is an urgent need for provisional measures to prevent irreparable harm to the rights at issue in this dispute. The requirements of urgency and irreparable harm are more than fully satisfied here. This case for provisional measures is among the most compelling that have ever been heard in this great hall of justice. As the court has emphasized in its prior rulings on provisional measures, quote, the condition of urgency is met when the acts susceptible of causing irreparable prejudice can occur at any moment before the court decision on the case. That is precisely the situation here. It is exactly what the UN fact-finding mission concluded in its report of 16 September 2019, which you will find at tab 2, page 3 of your judges' folders. The mission concludes, based on its findings, that grave violations against the Rohingya continue, and that there is a real and significant danger of the situation deteriorating further. The mission also has reasonable grounds to conclude that the evidence that infers genocidal intent on the part of the state against the Rohingya, identified in its last report, has strengthened that there is a serious risk that genocidal actions may occur or recur, and that Myanmar is failing in its obligation to prevent genocide, to investigate genocide, and to enact effective legislation criminalizing and punishing genocide. These conclusions, as you have heard, are based on thorough and meticulous investigations carried out over a 2-year period and resulting in voluminous reports totaling over 700 pages. Even more recently, on 26 November 2019, the United Nations Special Rapporteur on the human rights situation in Myanmar wrote, as you can see at tab 14, the Rohingya still living in Rakhine State continue to be denied their most basic rights and are confined to either closely guarded internment camps or remote villages. The system of oppression remains unchanged, and they are at real risk of recurring genocide. Mr. President, the evidence that is now before you is several orders of magnitude greater and even more compelling than the evidence submitted by Bosnia in 1993, which the court found sufficient to determine that, quote, there is a grave risk of acts of genocide being committed. On that basis, the court indicated provisional measures to ensure that the parties, quote, do all in their power to prevent the commission of any such acts in the future. Since 1993, The court has repeatedly found the requirements of urgency and irreparable harm to be met in situations where the threats to human life or to other fundamental human rights short of life itself were considered serious. In Democratic Republic of Congo v. Uganda, the court ordered provisional measures based on its finding, quote, that persons, assets, and resources present on the territory of the Congo, particularly in the area of conflict, remain extremely vulnerable, and that there is a serious risk that the rights at issue in the case may suffer irreparable prejudice. In the certain activities case, the court ordered provisional measures prohibiting Nicaragua from sending its personnel into disputed territory, in part because, quote, the situation gives rise to a real and present risk of incidents liable to cause irremediable harm in the form of bodily injury or death. In Ukraine v. Russia, the court ordered provisional measures on the ground that, quote, Crimean Tatars and ethnic Ukrainians in Crimea appear to remain vulnerable because, quote, certain rights in question in these proceedings, in particular, political, civil, economic, social, and cultural rights, are of such a nature that prejudice to them is capable of causing irreparable harm. Here, the Rohingya are not only deprived of their political, social, and cultural rights, they are threatened with massive loss of life itself. And striking at the heart of these proceedings, with loss of their very existence as a group. In Qatar, the United Arab Emirates, the court ordered provisional measures to protect the rights of Qataris living in the UAE. The court found that, quote, individuals forced to leave their own place of residence without the possibility of return could, depending on the circumstances, be subject to serious risk of irreparable prejudice. At the time the court made this finding, according to the U.S. fact-finding mission, the Rohingya in Myanmar were suffering an even worse fate. They too were forced to leave their own place of residence without the possibility of return. But in Myanmar, the UN fact-finding mission found that this was because the army, the Tat Madar, deliberately burned thousands of their homes to the ground, often with family members forced to remain inside, and went on to slaughter masses of men, women, and especially children, with the intention of destroying the Rohingya as a group. Since then, the threat of genocide has not abated, but grown even worse, as the UN fact-finding mission concluded in its report of 16 September 2019. Evidence of Myanmar's genocidal intent toward the Rohingya has actually, quote, strengthened in the past year. In the case of Qataris living in the UAE, the court was of the view that, quote, a prejudice can be considered as irreparable when individuals are subject to temporary or potentially ongoing separation from their families and suffer from psychological distress, when students are prevented from taking their exams due to enforced absence, or when the persons concerned are impeded from being able to physically appear in any proceedings or to challenge any measure they find discriminatory. Mr. President, the Gambia agrees that these are very important human and civil rights, whose interim protection by the court is justified where the facts show that their enjoyment is threatened irreparably. If that is so, then how much greater is the justification for provisional measures here? This case is about the commission of genocide, the most heinous of all crimes. The evidence before you makes clear that provisional measures are urgently needed to protect a group that is at serious risk of suffering further genocidal acts, which independent observers have warned are capable of recurring at any time, including another clearance operation, which is Myanmar's own for the targeted killing of Rohingyas, burning of their homes and villages, and especially brutal and depraved acts of sexual violence against women and girls. The very kinds of atrocities the Genocide Convention was intended to prevent. Mr. President, if provisional measures were justified in all of these cases, they must be justified in this one. More recently, in the alleged violations of the Treaty of Amity case, the court, using language that is especially pertinent here, found that, quote, a prejudice can be considered as irreparable when the persons concerned are exposed to danger to health and life. The court ordered provisional measures, notwithstanding the assurances given by the United States that it would use its best endeavors to ensure that humanitarian or safety of flight-related concerns receive full and expedited consideration. The court explained, quote, while appreciating these assurances, the court considers nonetheless that insofar as they are limited to an expression of best endeavors and to cooperation between departments and other decision-making agencies, the said assurances are not adequate to address fully the humanitarian and safety concerns raised by the applicant. Therefore, the court is of the view that there remains a risk that the measures adopted by the United States may entail irreparable consequences. Without question, if humanitarian and safety concerns merited provisional measures to protect the people of Iran against an economic and commercial embargo, they are absolutely indispensable here, where the Rohingya face every single day the risk that they and their children will be killed or raped en masse, pursuant to what independent expert investigators have found to be Myanmar's ongoing and strengthened genocidal intent. In the case between Iran and the United States, the court found that the assurances of the respondent state could not serve as a substitute for provisional measures. Even less can they substitute for provisional measures in this case. Myanmar, from its highest official levels, has been giving empty assurances to the United Nations repeatedly, since even before the first clearance operation in 2016, and it continues to do so. It backs them up with phony investigations, finding no wrongdoing whatsoever. A complete whitewash, in the words of a former United States ambassador, a total lack of accountability, according to the UN fact-finding mission. The UN Special Rapporteur on the human rights situation in Myanmar recently explained why Myanmar's assurances cannot be relied upon in a document you will find at tab 14. Those responsible for these violations enjoy impunity, which perpetuates the devastating cycle of abuse. This is because the emboldened military leadership retains a firm grip on politics and the economy, while the government has so far proved unwilling or unable to make any significant move against it. Under present conditions, the Special Rapporteur concluded Myanmar is simply, quote, incapable of delivering accountability. Incapable of delivering accountability. The Special Rapporteur ended with a warning that the military, backed by Aung San Suu Kyi, has responded with defiance and with the immediate threat of further atrocities present, more must urgently be done to prevent further tragedy. Mr. President, as if to prove the Special Rapporteur's point, soon after the Gambia's application was filed with the court, billboards were posted across Myanmar like this one, which you will find at tab 20. The three smiling Tatmadaw generals behind the agent are Myanmar's Minister of Border Affairs, Minister of Defense, and Minister of Home Affairs. This shows, in fact, it can only have been intended to show that they are all in it together, and that Myanmar has absolutely no intention of holding its emboldened military leadership accountable. Mr. President, in these circumstances, for the court not to order provisional measures would be to completely ignore the imminent risk of death and destruction that the Rohingya face today and every day during the pendency of these proceedings. And it would be a complete break with the long and distinguished line of jurisprudence that the court itself has firmly established and very recently confirmed. There is law, and there is also morality. They are not opposed. In its advisory on reservations to the Genocide Convention, the court explained, the convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object, on the one hand, is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. What happens when international institutions lack the will to uphold these elementary moral and legal principles? Lieutenant General Romeo Dallaire, commander of the UN peacekeepers in Rwanda in 1994, offered sobering testimony, which you will find in your judges' folders at tab 21. Almost 50 years to the day that my father and father-in-law helped to liberate Europe, when the extermination camps were uncovered, and when in one voice humanity said, "Never again," we once again sat back and permitted this unspeakable horror to occur. We could not find the political will nor the resources to stop it. There is no uncertainty about who we are. According to the report of the Independent Inquiry into the Actions of the United Nations during the 1994 genocide in Rwanda, quote, "The United Nations failed the people of Rwanda during the genocide in 1994. It is a failure for which the United Nations as an organization, but also its member states, should have apologized more clearly, more frankly, and much earlier. Mr. President, members of the court, apologies are not enough. They always come too late, when there is already something to apologize for. The failure to act and the resulting catastrophe that might have been prevented. And as history has shown, when the international community fails to act, it only invites further catastrophes. In Lieutenant General Dallaire's distressingly prophetic words, quote, "The genocide in Rwanda was a failure of humanity that could easily happen again." Mr. President, tragically, it has happened again in Myanmar, and still, the world has not yet found the will or the means to stop it. So say the independent fact-finding reports of highly credible investigators acting under the mandate of the United Nations. So say the most respected international experts on genocide, including those of the United States Holocaust Memorial Museum, who have written, "Shocking in scale, the mass atrocities against the Rohingya were predictable and preventable. Following decades of escalating persecution, including the revocation of citizenship and restrictions on basic freedoms, the Burmese government, as well as the international community, failed to respond to the early warning signs and prevent the genocide." Mr. President, genocide in Myanmar is happening still. Of course, Myanmar denies this, as have all the perpetrators of genocide throughout history. But the UN fact-finding mission, the UN Special Rapporteur, and other independent experts and observers have heard all of Myanmar's excuses and explanations and found them unconvincing and even cynical, and refuted them one by one in their detailed reports. The Gambia has come to the International Court of Justice in the face of an insufficient response by the international community, because, as its agent so eloquently put it, it has faith in this court to uphold the Genocide Convention and the humanitarian and civilizing purposes it reflects. The time to prevent further genocide is now, because nothing less will save the Rohingya from their ultimate destruction as a group. In these proceedings, the Gambia asks you to order Myanmar to do what it is already obligated to do under the Genocide Convention, but has refused to do and cannot be counted upon to do without the court's intervention. The court spelled out these obligations in its judgment in the Bosnia genocide case, where it made clear that the obligation to prevent genocide does not only come into being when perpetration of genocide, that, the court said, would be absurd, since the whole point of the obligation is to prevent or attempt to prevent the occurrence of the act. In fact, the state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it a deterrent effect on those suspected of preparing genocide or reasonably suspected of harboring specific intent, it is under a duty to make use of these means. Mr. President, the Gambia asks you to order provisional measures that require Myanmar to fulfill this obligation by refraining from any further acts of genocide and by using every means at its disposal to prevent further acts of genocide against the Rohingya people. In 2 words, Mr. President, the Gambia asks you to say to Myanmar, never again, and to say it in the clearest of terms and with all the legal and moral force that this highest of all international judicial authorities commands. The UN fact-finding mission, at the conclusion of its report of 16 September 2019, made a series of recommendations to the United Nations and the international community on actions that must be taken to prevent further genocidal acts against the Rohingya people. Among them is this one, at tab 2, page 22. Encourage and support states party to the Genocide Convention to bring a case to the International Court of Justice against Myanmar for breaches of its obligations under the Genocide Convention. The Gambia has heeded that call. On its own behalf, as a state party to the Genocide Convention, on behalf of the 57 member states of the Organization for Islamic Cooperation, which have fully endorsed and encouraged this case, and most especially on behalf of the Rohingya people, whose hopes for survival as a group in Myanmar now rest with you. On behalf of all, Mr. President, the Gambia calls on this honorable court, humbly and respectfully, to indicate the particular provisional measures that are urgently required in these exigent circumstances, and that my distinguished colleague, Professor Sands, will describe for you. Mr. President, members of the court, this concludes my presentation. I thank you, as always, for your kind courtesy and patient attention, and I ask that you call Professor Sands to the podium.
I thank Mr. Reichler for his statement. I now invite Professor Sands to take the floor. You have the floor.
Mr. President, Madam Vice President, members of the court, it is a privilege, albeit a regrettable one, to appear before you on behalf of the Gambia on this application concerning the crime of genocide. My colleagues have addressed the evidentiary and legal prerequisites for the order on provisional measures that we seek, and my submissions now turn to the specific provisional measures we request and why they are needed. This court is the ultimate guardian of the Genocide Convention, and it is on you that the eyes of the world are turned today at this preliminary stage of the proceedings. The court's well-established conditions for the grant of provisional measures are amply met, as you have heard. This application is brought to protect hundreds of thousands of people from a multitude of acts that are genocidal. Back in 1948, the drafters of the convention well knew the consequences of a failure to prevent acts of genocide. They created a system to allow steps to be taken to respond to a future genocide. That is why a convention was proposed. That is why it was negotiated and adopted. That is why Article 9 bestows a jurisdiction on this court to ensure that the obligations set forth in the Convention and the are respected, including by provisional measures. Mr. President, as you well know, this is not the first time the court has been asked to protect rights under the Convention. In April 1993, in the Bosnian genocide case, the court ordered the government of the FRY to take all measures within its power to prevent commission of the crime of genocide, and it did so by a unanimous decision. It also voted by 13 votes to 1 to adopt a further order addressing in particular the acts of military, paramilitary, and irregular armed units. 5 months later, it reaffirmed those measures and called for its earlier order to be immediately and effectively implemented. Mr. President, we do not wish to be back here in 5 months' time. Our hope is that the court will order provisional measures that are clear and specific. Our expectation is that Myanmar will comply fully with a binding order of this court. The provisional measures we seek are concerned, all of them, with genocide-related activity, as ad hoc Judge Lauterpacht put it back in 1993. As Mr. Reichler made clear, it's difficult to imagine many situations the court has faced in which the need for provisional measures has been more acute. The evidence before you, frankly speaking, is overwhelming. The risk of destruction of the Rohingya group, in part or in whole, is very real. In light of that evidence, it cannot reasonably be argued that there is no further risk of genocidal acts. And the further harm that is anticipated to occur cannot be undone or recompensed. As the court put it in the Bosnia case, and I quote, "No reparation could efface the results of conduct which the court may rule to have been contrary to international law." In the face of Myanmar's failure to give effect to a multitude of calls, repeated, to desist from acts that give rise to genocide, we submit that this court must act. And the question before you is not whether to order provisional measures, but what provisional measures to order. The Gambia seeks 6 provisional measures. The first and the second require Myanmar to act with immediate effect to prevent the further genocide of the Rohingya group. The third measure requires Myanmar not to destroy or render inaccessible any evidence relating to the events already described in the application. This is to ensure the integrity of the proceedings before this court and the proper fulfillment by the court of its dispute settlement function. The fourth and fifth measures require both parties not to take any action and positively to act to prevent any action which might aggravate the dispute or render it more difficult of resolution, and to provide a report to the court on implementing measures. And the sixth measure, which we made available yesterday, requires Myanmar to cooperate with the United Nations bodies that seek to investigate the acts that are the subject of this case. Each of these requests is based on the court's jurisprudence. Turn to the first 2 provisional measures. They are directed, Mr. President, to Myanmar's obligation to prevent genocide. First, by taking all measures within its power to prevent genocidal acts against the Rohingya group, and second, by ensuring in particular that any military, paramilitary, or other organizations under its direction or support or subject to its control or influence do not commit acts of genocide against the Rohingya group. The written application sets out the specific acts which are sought to be prevented. All of them fall within the list of genocidal acts defined in Article 2, and as you have heard, there is compelling evidence that each of these acts has already been perpetrated and is being perpetrated right now against the Rohingya group by Myanmar or by entities acting under Myanmar's control or at its behest. Accordingly, the request for these two provisional measures goes to the very heart of the Gambia's application to uphold and to enforce the Genocide Convention and its rights under it to protect the Rohingya group against total or partial destruction. Mr. President, the measures requested are grounded in the recognition of, I quote, the value in humankind, end of quote. The idea that every human being is expected to have, and I quote, a value and dignity of her kind or his kind, end of quote. Those words will be familiar to some in the room. According to the United Nations fact-finding mission, regrettably, that is not the situation in Myanmar today, as far as the Rohingya are concerned. Indeed, in 2016, the State Councillor and Foreign Minister of Myanmar is reported to have insisted to the United Nations that it must refrain from even using the word Rohingya. And I quote, "We won't use the term Rohingya because Rohingya are not recognized as among the 135 official ethnic groups," end of quote. The agent's ministry affirmed that statement. The Foreign Ministry of Myanmar has simply refused to recognize the Rohingya as a group, and it has overtly sought to dehumanize the group and its members. In September 2018, the UN fact-finding mission reported on a communication from the Foreign Ministry that included links to 4 videos about the August 2017 events in Rakhine State. The 4 videos were each imbued with explicitly anti-Muslim and anti-Rohingya messages. The UN fact-finding report does not mince its words. It states, and you'll find it at tab 1, as follows. The State Councillor, Daw Aung San Suu Kyi, has not used her de facto position as head of government, nor her moral authority, to stem or prevent the unfolding events or seek alternative avenues to meet the government's responsibility to protect the civilian population, or even to reveal and condemn what was happening. On the contrary, the civilian authorities have spread false and hateful narratives, denied the Tatmadaws' wrongdoing, blocked independent investigations, including of the fact-finding mission, and overseen the bulldozing of burned Rohingya villages and the destruction of crime sites and evidence, end of quote. And the fact-finding mission is not alone in expressing these concerns. Very recently, the UN Special Rapporteur on the human rights situation in Myanmar has gone even further in her expression. The Gambia's application is premised on the view that the Rohingya group and its members are a part of humankind, and they have a value and a dignity, and that they are entitled to the fullest protections of the Convention from any act which is plausibly capable of being characterized as genocidal before it is too late. Given the evidence before the court as to what has already occurred, and given the length of time these proceedings are likely to take, the need for protective measures to assure the survival of the Rohingya as a group in Myanmar and the Gambia's rights as a state party to the Convention is pressing and urgent. The primary obligation arising under Article 1 of the Convention and the rights it creates is the duty on state parties to prevent genocide. That duty seeks to give effect to the words of Raphael Lemkin, whose book Axis Rule in Europe, published in the autumn of 1944, first coined the word. You will have it at tab 23, and this is from that first edition. Genocide does not necessarily mean the immediate destruction of a nation, he wrote. It is intended, rather, to signify a coordinated plan of different actions aiming at the destruction of the essential foundations of the life of national groups. It is not a single act, genocide. It does not occur at a single moment. It comprises different actions, the objectives of which include the disintegration of social and political institutions, followed by, as Lemkin put it, the destruction of the personal security, liberty, health, dignity, and even the lives of the individuals belonging to such groups. The intervention of a court, therefore, does not have to await the final moment, although in the case of the many thousands of lives of individuals belonging to the Rohingya group, that moment has already come and gone. Genocide is a continuum, and you are called upon to act now as acts of genocide have occurred and are continuing to occur. The ILC articles on state responsibility make clear that obligation to prevent a given act extends over the entire period during which the event continues, an approach the court confirmed in its Bosnian genocide judgment in 2007. The order for provisional measures we seek would require Myanmar to respect and comply with its Article 1 obligation. It is the only means to ensure that the rights of the Gambia and of the Rohingya group are further safeguarded under international law. It is the only means to ensure that the ability of this court to root is not compromised by further acts of Myanmar rendering the partial or total destruction of the Rohingya group in Myanmar a fait accompli. The first two provisional measures sought in this application are equivalent to those ordered by this court in the Bosnia genocide case, and they serve the same conservatory purpose. Here, as then, an order on provisional measures does not anticipate or prejudice the final judgment, and it is in conformity with the nature of interim measures because they are the only means to preserve the substance of the rights pendente lite. Furthermore, just as in that and other cases in which the court has considered provisional measures, irreparable damage is at risk here. You will recall, to achieve its protective function, and having regard to the experience in the Bosnia case, and in particular, and I emphasize this, the fact that the killing of 8,000 men in Srebrenica occurred 2 years after the court ordered provisional measures. The Gambia submits that something more is needed here, that the court's order should and must identify on a non-exhaustive basis particular acts of genocide, which the evidence shows have already been committed and which must not recur. As set out in the reports of the UN fact-finding mission and other bodies, these acts include extrajudicial killings, physical and mental abuse, rape and other forms of sexual abuse, the destruction of homes and villages, forced starvation, denial of access to medical treatment and humanitarian assistance, and restrictions on movement. In our respectful submission, your order must explicitly set out acts of a genocidal nature which are to be avoided and prohibited. Specificity of an order can only help to contribute to their recurrence. In the present appalling circumstances, the court's order, should we submit, indicate provisional measures of as great a specificity as possible. Only in this way can we hope that the rights of the Gambia and the safety of the Rohingya group be fully protected. Mr. President, I turn briefly to the third, fourth, fifth, and sixth provisional measures. The Gambia also seeks what might be called procedural provisional measures, with the aim overall of protecting the integrity of the proceedings before this court. The measures requested have several objectives. In particular, they will first contribute to the preservation and accessibility of evidence on the merits of the dispute. Second, prevent any aggravation or extension of the dispute between the Gambia and Myanmar. And third, assure the implementation of the foregoing provisional measures by providing for reporting on them within 4 months of their issue. To these measures, the Gambia has added a sixth provisional measure. This is necessitated by Myanmar's persistent refusal to cooperate at all with the United Nations fact-finding mission or any other independent fact-finding mission, including the UN Special Rapporteur. In particular, Myanmar has refused all such missions access to Rakhine State, to the scenes of the Tatmadaws clearance operations, or to the places where genocidal acts against the Rohingya are reported to have been committed. This deliberate effort to prevent access to evidence of genocide, which is documented in the UN fact-finding mission's reports, must not be allowed to continue during the pendency of these proceedings, because, we say, it constitutes an obstruction of the fair administration of justice, which it is the court's responsibility to ensure. And so, accordingly, as a sixth provisional measure, we request that Myanmar be ordered to grant access to and cooperate with all UN fact-finding bodies that are engaged in investigating alleged genocidal acts against the Rohingya, including the conditions to which the Rohingya are subjected. These provisional measures, the third through the sixth, are necessary to ensure that the court is properly equipped in due course to adjudge the merits of the underlying claim, including the facts, and to ensure that the dispute can be considered fairly and comprehensively by reference to all relevant material. The order is necessary where there is an evidential imbalance between the parties, since the acts complained of occur on the territory of Myanmar, which has the primary control of all the first-hand evidence. In such a case, where access to various areas has been prevented, the court, we submit, has a responsibility to ensure the fair disposal of the claim. Moreover, the indication sought will also assist in protecting against non-compliance or inadequate compliance, as so regrettably happened in the Bosnian genocide case. The court has, in other cases that involve the rights both of states and individuals, required parties to inform it of the progress made in implementing its orders. We are not looking for an excessively active, continuing role in these matters, but given the gravity of the situation, given the likely length of future proceedings, and given, in particular, what occurred in Bosnia and Srebrenica after the court's provisional measures in that case, we submit that the facts of this case call for a clear reporting requirement. Mr. President, to sum up, the indication of provisional measures is, we recognise, without prejudice to the merits of the underlying claim. Yet the evidence at this stage indicates grave violence and genocidal acts against the Rohingya group in flagrant contravention of the Genocide Convention and in breach of Gambia's rights. The consequences of not indicating clear and particularized specific provisional measures and not taking steps to intervene in Myanmar's disregard of its international obligations would, we fear, be very grave indeed for the Rohingya group, who remain at real risk of further genocidal acts, for the future effectiveness of the Convention, for the rights of the Gambia, and for the reputation of this court, which is equipped with and must exercise its powers to afford an effective realization of the rights under the Convention. That means we respectfully submit, indicating the provisional measures sought by the Gambia, as well as any others in addition the court might deem appropriate. The balance of equities points overwhelmingly in favour of far-reaching provisional measures. Mr. President, Madam Vice President, members of the court, many in the Great Hall today, which happens to be International Human Rights Day, will have read a fine book with the title If This Is a Man by the Italian writer Primo Levi. It was published in 1947. You will find the relevant extract at tab 24. In the preface, Primo Levi recorded a concern which might be said to be of universal application. He wrote, and I quote, "Many people, many nations can find themselves holding, more or less wittingly, that every stranger is an enemy. When this happens," Primo Levi continued, and I quote, "when the unspoken dogma becomes the major premise in a syllogism, then at the end of the chain there is the lager." In the case of Myanmar and the Rohingya, when it comes to the merits, this court will have the authority to break that chain. In the meantime, what you have is the power of interim relief, and we place our hope in your willingness to fully discharge your judicial responsibility and powers. Mr. President, members of the court, I thank you for your kind attention. This brings the Gambia's first round to a close.
I thank Professor Sands. Your statement indeed brings to an end today's sitting. The court will meet again tomorrow, 11 December 2019, at 10 a.m. to hear this first round of oral observations of Myanmar. The sitting is adjourned.